Thank you, everyone, for joining us. You're in for a real treat today, as we'll be talking about one of the most significant criminal cases of 2020, both in terms of white-collar criminal defense and economic sanctions. Brian Heberling, who is one of our white-collar defense experts and the defense counsel in this case of Ali Sadr, is going to discuss what happened in the criminal prosecution. I'm not going to spoil the surprise ending. And then Nick Turner and I will put that case sort of in the context of economic sanctions. Nick will speak about it from the perspective as a former in-house regional sanctions officer for a multinational bank. And I'll talk about it as a former federal prosecutor and the head of enforcement at BIS. And Nick and I are both in the Hong Kong office of Steptoe and Johnson. Brian is in the DC office. And as that little video showed, we're going to ask questions as we go, and you'll need to respond in order to get your CLE credit. So our first question, if you could answer this for our background, are you more of a white collar or a sanctions compliance lawyer? If you could click on one of those, that would be super helpful.
Thanks.
Okay, looks like we mostly have sanctions compliance officers, folks and lawyers, so that's great. Brian, why don't I hand it over to you at this point to give us some background and talk about the trial.
Thank you so much, Wendy. Let me make sure I can advance the slides here. 1 second. Okay. Good morning, everyone, or good evening, depending on where you're joining us from. Thank you for participating today. I'm really delighted to talk about this case, which dominated at least the first part of my year last year. We represented an Iranian-American named Ali Sadr, and the case for him began on a day in mid-March of 2018 when he and his mother were boarding an airplane in Dulles Airport, heading to Heathrow in London, and he was pulled out of line and arrested with no prior notice on a sealed indictment that had been filed in the Southern District of New York. Came as a complete shock to him. Had no prior criminal record, no idea he was under investigation. And it launched this, 2-year saga that ended with a trial last year and some events to follow that we'll talk about. But, Ali was a very interesting client. He was born in 1980 in Tehran, the year after the Iranian Revolution, had a very, challenging in some respects youth growing up in that environment, but was in a Western family with a couple of sisters, mother and father. In the late 1990s, he and his mother and sisters emigrated to the United States. His father stayed behind. He had a significant business conglomerate called the Stratus Group, and he didn't take the trip with them. But Ali began, his life in the U.S., the final years of high school, and then, got his education, became totally Americanized, went to Cornell, and, founded a few businesses afterward. Was living a normal American life until 2010, when his immigration status got messed up by, it's sort of a long, complicated story, but it ends with he had to leave the United States in order to get himself in a position where he could come back on a green card. And so he did. And when he left, he hadn't previously worked for his father in any capacity, but his father was handling a major construction project. He had received some finance experience from his work after college, and so he joined the team. And the project was a massive construction project in Venezuela, where an Iranian company named the Iranian International Housing Corporation had contracted with a subsidiary of PDVSA, the big Venezuela state-owned company, to build essentially a small city. It was a $475 million contract. And Ali's father assumed control of that company and began the construction around the time that Ali joined the project in 2010. It was, a straight construction project. No terrorism angle, no oil financing, nothing that, many of you sanctions lawyers may be familiar with. This was literally building low-income housing in Venezuela with no connection to the U.S. But Ali's role was to handle the finances of the project. And that's what the case we handled ultimately revolved around. And in particular, $115 million in payments made for this construction to the, we called it the IIHC, the International Housing Company, Iranian International Housing Company, I should say, which is a very important part of its name. So this is a busy slide, but let me try to unpack it a little bit for you. This talks about the way the money flowed in the case, which was essentially the entire the subject of the criminal case. In the beginning days of the construction project, the Venezuelan company actually paid in euros, and so you can see in Route 1B there on the slide, no involvement whatsoever of any U.S. banks. The Venezuelan company paid the Iranian International Housing Company in euros, and had the payment flow continued that way, we would not be here. There would have been no U.S. case whatsoever. But when Ali joined the team and began handling the finances, there was a decision made to change the way in which they were paid and to convert from euros to U.S. dollars. And when they did that, they also changed the payment flow because routing U.S. dollar payments to a company named the Iranian International Housing Corporation was simply not possible. That name, would have hit every single bank's compliance flags, and even a purely private, non-government-owned company with that name would not have been able to receive U.S. dollar payments without a time-consuming internal bank review before the funds were released. So he involved a couple of affiliates of the company with different names, a Swiss company and a Turkish company, and they received the payments for the construction in bank accounts in Switzerland. So the money flow went from PDVSA's accounts, which were foreign bank accounts, to these two companies' Swiss bank accounts, denominated in U.S. dollars. But as you can see in Route 1A there, they had to use a U.S. correspondent bank to clear the wire transfers. So foreign bank to foreign bank, cleared by a New York bank. And that's the hook that the U.S. government used to bring this case. Route 2 is shown here just to reflect the fact that most of the funds received were actually turned back and put into the project to buy things like construction supplies and equipment and pay salaries. And you might ask, why didn't they just get paid in Venezuela in bolivars and avoid all of this headache? That was an option, but not one that was realistic because of the hyperinflation, that the bolivar was experiencing at the time. I mean, literally dropping in value week to week. So that wasn't a route that they chose. But this, this represents the money flow, and the stop sign there reflects the fact that none of these dollars, no currency ever was transferred to any bank account in Iran. The money that came in either was routed back to the project to conduct the construction, or any profit that remained was kept outside of Iran. So the charges, he was charged in I believe it was a 6-count indictment. There were basically 4 buckets of charges. There were the straight sanctions offenses, which were, conspiracy to violate IEPA and the Iranian sanctions regime by exporting services to Iran. And the services were these financial services, the wire transfer clearing by the U.S. banks. There was a Klein conspiracy, which was the conspiracy to defraud OFAC in its ability to enforce the sanctions regime by concealing information from it. There were some bank fraud charges in which the U.S. correspondent banks were alleged to be the bank victims of the crime. And even though they lost no money, and it wasn't their money that was being transmitted through their accounts, the government took the position that they had the right to control their funds and to choose whether to process transactions, and they were deprived of information that might have led them not to process the transactions because of the risk of, quote unquote, strict liability sanctions enforcement and consequences that could have befallen these banks. And we'll come back to that concept. And the 4th bucket was just some derivative money laundering charges. So we're going to get back to a little bit, of the case, but we have to do these questions for CLE purposes. So question for the audience is whether this type of money flow, payment flow, whether you've seen it before in any of your recent cases. And we'll give you a second to answer.
I think we can go to the answers, Brian.
There we go. Thank you. All right. So most of you haven't. Some don't know and some have. So interesting. I mean, it was an unusual case, but not all that unusual, as Nick will explain based on some of the history he's seen out there.
Great. Thanks, Brian. Hello, everybody, and greetings from Hong Kong. This case might look familiar to many of you who practice in the area of sanctions or are working in sanctions compliance teams anywhere in the world. We see cases like this all the time where we have a transaction that is international and that transaction clears through a U.S. correspondent account in the United States. Now, you know that if a transaction touches on the United States, then it is subject to U.S. jurisdiction. And that's why OFAC and the Department of Justice and potentially other regulators might assert jurisdiction over that transaction. And this is a feature of U.S. sanctions, which is common to all types of sanctions programs, which are adopted under a law called the International Emergency Economic Powers Act, or IEPA. And once you understand that basic pattern, you'll be able to understand a lot of sanctions cases, including very famous cases involving individuals like Reza Zarrab, who also were picked up in airports and put on trial for using the U.S. financial system in relation to transactions with Iran. That being said, this case is not quite as simple as it seems. Although we have a company which is in Venezuela, at the time Venezuela was not subject to the type of sanctions that it is today. And although we have a company which is owned or controlled by an Iranian individual, the company is based in Switzerland, and in that case is not an Iranian company, it's a Swiss company. And because we're not talking about a specially designated national, the 50% rule doesn't apply in the same way. So it's not always as straightforward as it seems, and that's why it's important to look at all of the facts in the constellation in order to understand how the sanctions may apply. And Brian's going to tell us more about that as we talk about some of the evidence in this particular case.
Thank you, Nick.
Great.
So let's talk a bit about the trial. The trial occurred this year in March, the first 2 weeks of March, right before the pandemic shut down the courts. And it took place in the Southern District of New York in Manhattan, a very aggressive prosecution team. And, you know, their themes are, for those who've tried cases in the Southern District, were, you know, somewhat by the book. It was all about the money. You know, lies, they repeatedly emphasized. They focused on the fact that, you know, the emails and the documents shown that there was an effort to hide the Iranian connection to these payments. And, you know, they portrayed the sanctions regime and the regs that they charged in the case as simple. You know, they characterized Ali Sadr's scheme as complex, but as they said here, this is a quote from their opening statement, the rules are not. And, you know, as those of you know who are in the sanctions bar, that, you know, is far from reality. As I learned preparing for this case, I'm not a sanctions lawyer normally, although I had to become one for this trial. They also accused Ali Sadr of defrauding OFAC by his deception, and they harped on the fact that the U.S. Victim banks were exposed to massive liability because OFAC pursues a strict liability enforcement regime. They called an OFAC officer, a gentleman named Ted Kim, who testified to these you know, principles and talked about the rules. And their case lasted about a week and a couple of days. Our case was, we put on a case, which is not always, you know, the case in a criminal defense, but our client testified. He, you know, his defense was fairly straightforward. It was a lack of criminal intent. It was good faith. There was very little dispute over the facts of the case, and the emails were what they were. But his perspective was, I didn't believe I was violating the sanctions. There was no government of Iran involvement in this project. There were no SDNs involved in this project. We weren't involved in nukes or terrorism or oil, and the money all stayed outside of Iran. And I believe that complied with the sanctions. But you might ask, and certainly we felt we need to answer, then why were steps taken in emails and other communications to, conceal the Iranian connection? And our explanation, what he believed at the time, was it had to do with bank de-risking. And from his perspective, as an Iranian American who lived in this community, because of the onerous sanctions regime put in place, he experienced that banks got more and more cautious about processing transactions that involved Iranians. Even obviously legal transactions from one Iranian American to another, would get caught up in these bank filters. And from his perspective, had they transacted in the name, the Iranian International Housing Company, even though he believed it was perfectly legal to do so outside of Iran in this private context, the payments wouldn't have gone through, or they would have been delayed with a week or two or longer of an internal bank compliance team trying to clear the transaction. So as a result of that, he implemented this process where the other companies were appointed to receive payments. And that was our defense. So after the first week of the trial, we're on the weekend, we're preparing the defense case. We knew we had one more day of government evidence. We got this document dropped into our laps on Saturday evening. And it was previously not disclosed by the government. It became Government Exhibit 411. It was a letter from Commerce Bank to OFAC. And it related to the very first transaction at issue in the indictment, $29 million payment, one of the payments for the construction project that Commerce Bank played a role in clearing. And somehow it had hit the Commerce Bank filter, and they did what banks do. They conducted an internal review. And this is what they found and reported to OFAC, that the project or that the payment related to this massive construction project in Venezuela, that it was received by a Turkish company named Stratus, but Stratus appeared to have an affiliation with an Iranian company named Stratus, which was the conglomerate owned by Ali Sadr's father. By the way, perfectly easy to find out by a Google search, as I think Commerce Bank did. They reported it to OFAC, not as a self-disclosure, not as OFAC, we detected a violation of the sanctions that the bank was a part of, but as a sort of FYI. You can see here it was an information sharing letter. And, the upshot of it is that OFAC did nothing in response to the letter. And Nick, I know you wanted to say a few words about, these types of letters in your experience, working with banks.
Right. I think, as you mentioned, it's important to look at the type of letter that this is. It's not a self-disclosure, as Brian mentioned. It's not a blocked property report. It's not a rejected property report. It's just an information sharing letter, like an FYI. And those of you who have worked in the United States or worked with U.S. banks, you probably know that there's a lot of communication between financial institutions and OFAC. They like to share information. Banks like to cooperate with their regulators in the United States, and they often share information to alert OFAC to the possibility that an entity might have a connection to a sanctioned country or a sanctions target. So OFAC could pursue that and do some investigation if they wish to. And sometimes they like to share information just to evidence that they have effective controls, that they've identified certain information. And although they're not able to reach a firm conclusion about what it means, that's information that they want to share in order to evidence their commitment to compliance. And so these kinds of communications really aren't that unusual, and they're just part of the flow of information that goes between the U.S. government and the financial institutions.
Thanks, Nick. So, as you can imagine, when this letter came in on Saturday afternoon, we had just sat through a week of trial in which, among other things, an OFAC officer testified that Had OFAC only known about the Iranian connection here, it would have taken serious action, including potentially strictly enforcing the sanctions regime against the clearing banks like Commerce Bank. And lo and behold, after a week of that testimony, we get this letter, which we felt was fundamentally inconsistent with that view and obviously exculpatory on its face. And it was sort of like a bombshell moment. We all kind of, came together and said, why? What is this document? Why have we not seen it before? And frankly, for a moment, I was panicked that we somehow missed it in the discovery, given its significance. But it turned out that we had not received it before. And, over the next couple of days, a number of dramatic things took place in the trial. We instantly, within hours, sought relief from the court about this document, and it led to an exchange in which the court concluded that the government made a misrepresentation to the court and to us about the document. This, sort of 1, 2, 3 formulation. On the left, number one, this is how the government transmitted the document to us on Saturday afternoon after a week of trial. Not by saying, hey, we made a mistake. We just realized we have an exculpatory document that we failed to produce to you, notwithstanding our Brady obligations in a criminal case. No, they included it, buried in this sort of 15-bullet list of information that gets exchanged during a trial and said, with respect to Government Exhibit 411, this is just a document we intend to offer on Monday. When we brought it to the court's attention and said that this was exculpatory and we hadn't received it before, the court demanded an explanation, got one, and then asked again, and that's number 2 on this slide, where she wanted specifically to know, when did the government realize the document had been withheld, and what did it do when it learned that? How did it communicate that information to the defense? And in number 3 there, on this Sunday evening filing, the government letter was simply, the government made clear that Government Exhibit 411 was a newly marked exhibit, a non-responsive answer, and one that the judge took real offense to and found to be a misrepresentation. So we wound up in court on Monday morning arguing about what to do next. And, you can see this was Judge Allison Nathan, a well-respected judge in the Southern District of New York. And she, twice on the record said, this has a tip of the iceberg feeling to it. What else is out there? And I feel that way, not just because of the nature of the document, because of your lack of candor with the court about how this came to be. And so she demanded that the government go back that evening, scrub its files, and see what else may be out there. Now, difficult to do during a trial. We still had a trial day that Monday. The prosecutors were in court putting on the last day of their evidence. So this was not exactly an exhaustive review, but it did reveal, and this is information we got that evening, more, from our perspective, bombshell Brady evidence. This was an email exchange before Ali Sadr was indicted, where the lead prosecutor at the time was trying to get a witness from OFAC to testify in the grand jury. But he also said, hey, we'd like to provide you, OFAC, with information about our case, among other reasons, to give you the opportunity to take action on your own, if that's what you so desire. And the prosecutor transmitted effectively his prosecution memo to OFAC, this 80-page PowerPoint that laid out the entire case and all of the facts. And, what did OFAC do? Nothing. Again, literally nothing. No file opened, no investigation conducted. And, the court, in this transcript excerpt here, really got to the nub of it. As she said, Mr. Lynch, that was the lead prosecutor, he laid out every single fact of the case to OFAC, and they did nothing. Again, fundamentally inconsistent with the government's theory of the case about strict liability enforcement, and only had OFAC known, the world would have been different. So we fought about what the consequences should be. We asked for the case to be dismissed or a mistrial, and in the end, we didn't get it. We got a curative instruction from the court. We got some of the OFAC officers' testimony struck, and we got a stipulation that said that, OFAC received this information and effectively did nothing with it. But that was as far as she was willing to go at the time. So we proceeded, as I said, Ali testified, and we went to the jury with the case. I could probably fill another webinar with some of the strategic calls we had to make at the very end, including the effects of COVID, on our case. This was literally, those of you probably remember the week that things started shutting down. I remember, getting ready for the day I put the client on the stand the next morning, the day the NBA shut down its season. Things were happening, and we knew we had limited time. If we wanted a verdict, if we wanted this jury to stay intact, we needed to move. And so we curtailed our case. We were so confident in how it had gone and the way Ali testified. We put on no other witnesses after he was done, and we wanted to get to the jury. And even though we had an opportunity for a mistrial because of some jurors who got sick due to COVID, we decided we wanted the verdict over the government's objection, and we got it. And unfortunately, it was guilty. We were obviously shocked and disappointed given how we thought it had gone and our belief that our client was innocent. But we let the dust settle a bit. We went back to DC, picked ourselves up, and we got to thinking, kind of the same way the judge speculated during the trial, what else is out there? Why did we only receive this critical information in the final days of the trial? And so we started pushing. We sent letters to the government. We made more demands for Brady information, asked for explanations of how this all had happened. And what unfolded was something I've never seen in a criminal case, but we got production after production from the government of documents after trial that we'd never seen before. Again, I'm not going to go into great detail in this presentation, but suffice it to say, filled with exculpatory evidence. There was a missing audio recording of a critical witness interview that we'd been asking about for months and had been in the government's possession, but they never produced to us. There were witness statements from the CFO of the PDVSA company that was on the payor side of these transactions, who had told the Southern District prosecutors he didn't believe what they had done was illegal. We never learned that during the trial. And there were a few other categories as well. So we filed a motion for a new trial based on Brady violations. And, the documents kept coming in even after we filed that motion. On the day that the government was due to oppose it, rather than, submitting an opposition, I got a phone call from the chiefs of the section saying that they planned to drop the case. Obviously we were filled with joy with that news, overwhelmed with emotion. Our client was, through the moon, but we still had significant questions. How on earth could this happen? And so they filed a letter that day, the U.S. Attorney Jeffrey Berman, and asked the court to drop the case because the government determined it would not be in the interest of justice to further prosecute. We had some skirmishing, back and forth with the government about why, what else is out there. And we were fighting about, should the case be dismissed without prejudice, as the government's motion seemed to suggest, or with prejudice and done for all time, as we requested. And in the midst of it, before the court dismissed the case, the judge asked for answers, in particular about this Government Exhibit 411, but some other issues too. She asked the office to answer a series of questions. And what came out in response to that, this is still prior to dismissal of the case, was remarkable. Perhaps the most remarkable was what's presented in this slide here. This relates to that same document we were talking about. And as I mentioned, that was the document we got on a Saturday evening, after the first week of trial. So unknown to us at the time or to the court at the time, but this is an exchange that two of the prosecutors on the case had on the Friday evening before they gave us that critical exculpatory document. One of them chatted the other one saying, hey, they had found the document and it had dawned on them that it hadn't been produced and it was of some significance. And so one wrote to the other, I'm wondering if we should just wait until tomorrow and bury it in some other documents. And the second AUSA said, yeah, that's fine. And that's what they did, as you could see from that email, I showed you. Remarkable. Never seen anything like that in writing. Obviously completely inconsistent with the government's obligations of good faith and Brady obligations in a criminal case. They later explained themselves that they'd hoped if they didn't make a big deal out of it, maybe we might not object or even notice. We did, obviously. And even later, when the judge called upon the executive leadership of the office to explain what happened, they sort of euphemistically called it a Friday night lapse in thinking. It was, I think it had a real impact on the judge. And this was just one of a few other significant events I won't go into in great depth, but those witness statements of the PDVSA CEO that, they had previously provided to us, in which he said we thought this was legal. We thought those had just gotten lost in the bustle of a criminal case. But in fact, there was a pretrial discussion between two of the prosecutors by email. Hey, this looks like Brady. Do you think we should talk about it with one of our chiefs? And the other one said, yeah, maybe we should. Never followed up, never produced the information. And there were some revelations, too, about some of the government's representations in search warrant litigation we had pre-trial that became relevant later. So what did the judge do? She ultimately, Wendy, go ahead. Sorry, I see you there.
But no, I just wanted to ask you, if you would, Brian, explain what Brady violation is for folks that are not necessarily in the white collar world. That might be helpful in understanding the significance of these non-disclosures.
No, absolutely. I'm sorry. So Brady stands for just the name of a Supreme Court case, but it stands for the proposition that the prosecutors are obligated to provide exculpatory information to the defense. There's a whole lot of open and well-litigated issues about what sort of information has to be provided, when does it have to be provided, who's obligated to make the disclosure. But by any calculation, this was exculpatory evidence, and the judge immediately recognized it. We immediately recognized it. The prosecutors maintained that they didn't, and that they blamed it on trial blinders, but they tried to argue that the Commerce Bank document was actually helpful to their case. Those were some serious blinders if they in fact had a good faith belief in that view. Hard to see it from our perspective and the judges, but be that as it may. So that's the Brady obligation, and it's courts have held that it must be disclosed in enough time to be of use by the defense at trial. So mid-trial, is a problem, and certainly after trial is a real problem. We had no ability to use any of the information we got after trial. And, some might say, well, you got the important stuff with a week to go in trial or a couple of days to go in trial, wasn't that enough? And it is true that we were able to make some use of it. We were able to, make some jury arguments as a result of it. But we were deprived of doing any investigation to find out more about it. And as it turned out, there was a ton of stuff within OFAC about this issue that would have been real helpful and that we got after trial. It also would have dramatically shaped, how we presented the case in opening. And I think it would have crushed the OFAC experts' testimony. So, you can see mid-trial Brady revelations are a real problem. But thank you, Wendy, for us criminal defense lawyers take it as second nature. So what did Judge Nathan do at the end of the day? She accepted our request not to just enter a nollie prosequi, which I hadn't even heard of before this, but essentially would have left the government with discretion to proceed again against our client. She dismissed the case with prejudice, and she entered this order that included language we requested, saying there was never a judgment of conviction in this case, and the jury's verdict is vacated with no legal effect. That was really important for us because Ali Sadr wants to live his life in the United States. I mean, this was a detour, this project, while he got his immigration status sorted out. But since got his green card, and one of his principal motivations in defending this case was he views himself as an American. And had he been convicted or taken a plea, even a no jail type plea, that had a felony conviction, he would have been disqualified and not able to remain in the United States, would have been stripped of his immigration status. So this language was critical in helping him solve that problem. What are some of the takeaways? We've talked about some of this already, but I mean, basically, OFAC was put on notice of the entire government theory of the case. Once, literally, by receiving the prosecution memorandum, that was about a year and a half before indictment, and even earlier than that, they received enough from Commerzbank that they could have taken any number of actions against Ali Sadr, against the Stratus Group, his father's company, against Commerzbank, had it really believed that it violated the sanctions by processing these transactions, but it didn't. Had that information been disclosed timely, the entire case would have been different. As I said, we were confident we would get a favorable verdict, even on the state of the record we had. It turned out we didn't. But had we had these facts in advance and been able to fully develop them, I actually think there's a reasonable chance we never would have gotten to trial. And that is not even accounting for the revelations that came out about the search warrant litigation that I mentioned, where the government effectively acknowledged some misrepresentations that, had they been known, I think the judge would have suppressed the email evidence that was really the entirety of the government's case. So on the Brady side, my final sort of takeaway for the white-collar lawyers out there listening is, obviously, don't give up on those issues. Keep pushing. If you get an opening, pull the string. The ball of yarn might unravel. In this case, it did in dramatic fashion, and led to the result, which, as I mentioned, we got the dismissal order I put on the screen. That ended the case for Ali Sadr, but the case is actually still going on for the prosecutors. Judge Nathan was not prepared to leave it there. She asked additional questions of the prosecutors about how this possibly could have happened. She issued an order in September, a few months after the dismissal, that she ordered every single AUSA in the Southern District of New York to read, and had the U.S. attorney certify compliance with that order, that chronicled all of the failings of the government team in the case. She referred 3 to 4 issues to the office of the OPR office, the Office of Professional Responsibility within the Justice Department. And she's still sitting on what to do with this issue of the misrepresentations regarding Government Exhibit 411. She's weighing whether to impose any sanctions, contempt proceedings, or making bar referrals with respect to the prosecutors who are responsible. And that issue is still live. We don't know how she'll come out. And there's a whole lot of information that's still under seal that a media organization has asked to be unsealed. And we've agreed there's no basis for it to be sealed. Those are the 2 issues still, pending on her plate. But those are the takeaways from the case. I think we have one more polling question here, so you can make sure you get your CLE. This may be a bit of a trick question, but the question is, do payments in U.S. dollars create jurisdiction for U.S. authorities? So take a second to answer that, and I'll give you one more anecdote from the trial. I don't know if it takes a minute to populate here or what, but well, while we're waiting,
yes.
Yeah, let me while we're waiting for that, I'm not sure if it'll populate or not. So the answer is, it's not the U.S. dollars that create jurisdiction. Had these payments in our case been made by someone carrying cash currency, that would probably not have been possible with $115 million. But an available option was, had the U.S. dollar transactions been cleared through a bank in Hong Kong instead of New York, there would have been no U.S. nexus and no jurisdiction. It's really the jurisdictional hook was the involvement of the U.S. clearing banks processing international wire transfers. If you don't have that, you don't have jurisdiction, at least under the facts we had. So U.S. dollars alone not enough. The other thing our client could have done, and we put on evidence of both of these theories, he could have continued to receive euros in his Swiss bank account. They had enough US dollars in-house, in stock to do foreign currency transactions and just exchange the euros for US dollars when received in Switzerland. Again, no jurisdiction, no problem with the US authorities, which, we thought had some jury appeal because it sort of highlighted how thin a reed we were talking about here. And also that, it supported our view that our client didn't have criminal intent. Had he known it was illegal to use the banks in this manner, which we still contest, he would have just routed things differently in euros through Hong Kong or making foreign currency transactions in Switzerland. So, Wendy, do you want to, or Nick, take away some of this?
No, I was going to make a quick comment about the defense takeaways before we get to the sanctions compliance takeaways, because one of the reasons that we thought this was a really interesting case for the sanctions lawyers who were listening to this is because of the criminal lawyers, would focus on the Brady violations and the misrepresentations and the fact that the judge, was so upset and took such extreme measures to counteract the impact that sometimes the key sanctions issues, when people are looking at this case, they kind of get buried. And so we really wanted to focus on the CX-411, the government's exhibit, and the OFAC decision, and put both of those together to understand why in a white-collar case, you need to be thinking like a white-collar lawyer, but in a sanctions case, thinking about, what challenges you could make in a white-collar context. So I thought it was a really interesting white-collar case. From a sanctions case, it's very interesting too, and we'll go ahead and get to that at this point because that US dollar nexus is so important. Nick, could you talk about that a little bit more?
Yeah, absolutely. I think it's probably one of the biggest misunderstandings about US sanctions. The US dollar, as Brian said, does not on its own create jurisdiction for OFAC purposes. In fact, what we really need to look for are the legal vehicles that are processing the transactions, because that's where you'll find the US persons. That means the US banks that are subject to OFAC jurisdiction, or you'll find those transactions clearing through the United States, like a correspondent account in New York. But if you can't find one of those touch points that has a US nexus, then your US dollar transaction could fall outside of OFAC jurisdiction. Now, there's a flip side to that, which people sometimes overlook, which is that you can have non-US dollar transactions which are subject to OFAC jurisdiction. And there was a recent enforcement case involving a company with a bank account in Dubai, and that company received payments in local currency, but it turned out that the bank was a branch of a US financial institution, and that is a US person. And so those transactions were subject to OFAC's jurisdiction. So I think if I were to point to some takeaways from this particular case, I think it highlights, for me anyway, the real importance of having OFAC experts involved in helping to understand the facts, particularly around payment flows, understanding how OFAC regulations apply to the specific fact pattern, in this case involving a company outside of Iran that happened to have a connection to Iranians, but may not have actually been subject to sanctions. And then finally, and most importantly for this case, understanding the kinds of evidence that might be available, especially communications between the financial institutions and OFAC. If you understand what goes on inside the bank, all the way from the operational level where the payments are processed up to the compliance divisions and even the legal division, there's a lot of communication that goes on and a lot of discussion between people who really understand the issues. And when that information is collected And when you combine it with information from OFAC and other sources, it can really shed a light on the underlying legal issues. And so having that perspective is really important. And in this case, we can see how important it was to this one individual and helping him win his case.
And I can't emphasize that enough in preparing for these cases, understanding where the sources of information that the government could be using, is using, and all of those communications that banks are going to be a key part of putting together a case. We did want to bring up the NDAA that in 2021 was amended. And it could have been in response to a significant series of rulings that the U.S. government obtained in trying to get evidence and some documents from China banks. And the government had a great deal of difficulty, the U.S. government did, in getting the information about the bank's customers in a North Korean sanctions case, and had to litigate it all the way up through the court systems in order to enforce subpoenas, because these banks were overseas. They were non-U.S. banks. They happened to have correspondent bank accounts in the United States, or they had branch offices in the United States. They had a nexus to the United States, but still the U.S. government could not get this evidence. And so what the NDAA was amended in 2021 to permit the DOJ and the Treasury Department to subpoena overseas bank records if the bank maintains a correspondent bank account with a U.S. bank, even if that correspondent bank account is not involved in a violation of the law that the DOJ and Treasury is investigating. It can be any criminal law that the DOJ and Treasury is investigating. So it goes even farther than the ruling in the China bank case that you may have been following. The government doesn't have to demonstrate a link between the account and the violations. So if the bank uses a U.S. financial system, all of its records are subject to subpoena. And further, the NDAA said that you cannot argue on the basis of secrecy laws or confidentiality alone to quash that subpoena. And a bank that is holding that correspondent bank account on behalf of the non-U.S. bank account must terminate the account or risk liability. So it's a very important amendment that folks should be aware of, particularly in the context of these sanctions cases. And finally, a point I want to make, if OFAC or BIS or the State Department isn't involved in a sanctions and export prosecution, there may be a reason why. In this case, I believe Brian would say they just overlooked it. They had other things to do. They were concentrating and focusing on other things. But the fact that they put a witness up on the stand to testify otherwise is problematic. And so you should think about why the agencies charged with enforcing and implementing these regulations, why they're not involved in the actual prosecution, why there's not a parallel proceeding. Brian, we've had a couple questions that have come in, and I do want to get to them about the experts. If you could talk about that a little bit.
Yeah, absolutely. So the questions, I don't know if everyone can see them, but the questions I've seen are whether we called an expert witness on sanctions. And the answer is no, although we did disclose one and we were prepared to do so. The expert battle was some of the toughest tactical decisions we had to make during trial. As I said, the government called this guy, Ted Kim from OFAC. They also had planned to call a so-called Iran expert, a guy named Mark Dubowitz, who was just an assassin who, was prepared to say that anything remotely connected to Iran must have to do with terrorism. I'm exaggerating a little bit, but not by much. And in the end of the day, they didn't call him. We chose not to call our experts. We had Cliff Burns from Kroll and Mooring lined up to testify. Many of you may know Cliff. And we had a witness who was associated with one of the Iranian-American nonprofits in DC who was prepared to testify about the effects of de-risking to sort of validate some of Ali Sadr's testimony. But ultimately, we concluded there was too great a risk on both sides because of, hypotheticals that could be posed to experts to box them into a corner. And we had engaged in substantial pretrial litigation with the judge and with the government. The judge ultimately ruled that this was a viable theory of sanctions prosecution. We thought we had a credible argument pretrial that it wasn't, and that the regs should be read literally, that a export to Iran means it must go to Iran, to a bank account in Iran, or otherwise. The government took the view that as long as these wire transfers were on behalf of or for the benefit of an Iranian company, it didn't matter that money never went to Iran. And so, at the end of the day, we were concerned that an expert on sanctions who might have, been able to testify about some points helpful to our defense, and what we were contemplating was sort of a lack of prior enforcement proceedings on facts resembling these. But we were concerned that the judge might allow the government to cross him into, hypotheticals loosely based on the facts of our case that would have been difficult for us to sustain. So we declined at the end of the day to call.
There was a question about why it was so important that OFAC didn't act earlier. And again, it was a question as far as what the substantive experts in this case that could have acted, could have brought a civil case, strict liability. They're very simple. There's a violation, you bring a fine, you bring an action. And those of you who've dealt with these know that the getting to the point where there's a settlement is pretty easy. But in this case, on 2 instances, OFAC decided not to take action. And Brian, I don't know if you had a chance to explain what the basis was for OFAC's decision not to take action, if it was a simple oversight or if there was a deliberate decision.
Ultimately, we don't know. We were told that the prosecutors made a full request to OFAC of any material within the agency related to this matter, and that we received everything that they produced. And so if we have the full universe of OFAC material, it appears that they never even opened an investigation. So we're not aware of sort of a deliberate examination of the facts, an affirmative determination that this doesn't violate the sanctions or is not worthy of our time. That was an argument we thought we could make or infer from the facts. I think the government tried to argue that, OFAC knew we were handling it. We, the prosecutors, were criminally enforcing, so they moved on to their other responsibilities. Where the truth lies, I think this was not a big issue for them. There are plenty of other matters that are in the heartland of what the sanctions are focused on. The support of terrorists or governments that support terrorists, other types of transactions that OFAC is more focused on than a private construction contract with the thinnest of thin reeds connecting it to the U.S.
Nick, would you handle the last question about when does counseling a client who's trying to steer clear of invoking U.S. jurisdiction, when that counseling might constitute impermissible facilitation? Do you handle that question?
Sure, that's a really fantastic question. It, of course, would depend on the facts. And as a general rule, if we're talking about a U.S. person who's acting as a legal advisor or a compliance officer, OFAC has issued guidance which says that U.S. persons are permitted to advise on the application of U.S. law to the activities of non-U.S. persons. So simply explaining whether or not U.S. jurisdiction would exist based on certain facts, that doesn't seem very problematic. Of course, if we're talking about a situation where the U.S. person is actually advising on how to structure a transaction or making referrals or in some way helping to carry out the activity, I think that might cross a line. But Generally speaking, if what we're dealing with is a non-U.S. person who wants to comply with OFAC sanctions and is committed to that compliance and wants to make sure that their transactions do not breach U.S. sanctions, and so they want to find a way to process their transactions which is safe and compliant, I think I would hope that OFAC agrees that that's perfectly acceptable and that's something that should be encouraged. But of course, it requires a careful understanding of the financial system and all the parties that would be involved in the flow of funds.
So, Wendy, if I can just add on this point, and this may chill a number of you, sanctions experts out there who probably counsel clients all the time on this issue. We face this issue in the criminal case in the following context. One of the charges against Ali Sadr, the conspiracy it was both to violate the sanctions under IEEPA and to evade or avoid the sanctions under IEEPA. And we had a debate with the government about what that means and how that should be reflected in the jury instructions in the case. And the government's view, and I think it was ultimately endorsed by the judge, was that if you intentionally structure your transactions in a way that if they were done one way, you'd violate the sanctions. So you change your behavior to do so in a compliant manner, but to avoid or evade the sanctions, you could be guilty of a federal felony. And our argument that ultimately lost, which was scary, is that suggests if someone affirmatively decided, look, if I get paid in U.S. dollars here, I'm going to violate the sanctions. So I shouldn't do that. I better get paid in euros in a way that, doesn't even touch the United States. And if I do, it's completely legal. That could be a federal felony because you're trying to evade the sanctions, which was really scary and allowed the government to make as a fallback argument, even if Ali Sadr is telling the truth and he believed it was legal to structure the payments this way, he still has effectively conceded that he did so to avoid the sanctions. And, thin line between compliance and evasion, I have to say.
I would love to be able to challenge that one on appeal, that jury instruction. And I know you guys probably were all ready to do that because that is pretty outrageous. So,
yeah, well, no appeal, fortunately, for our client, but there would have been a number of very interesting sanctions issues on appeal had we got to that point.
Right. Well, that I think is all. Those are all the questions that were asked. This has been terrific, and each time I hear about this case, I realize it's even more fascinating than you can even imagine from the news reports. So here's our contact information. If you have further questions you would like to ask us, or talk with us further, we'd be more than happy. We know that there's a number of folks who attended this conference that we were so pleased to see that, and we know that we'll have conversations going forward about this case and about some of the other work that we're doing for you all. So with that, I'll conclude. And Brian, would you like to make any final last statement?
No, just to thank everyone for joining. It was a real pleasure to talk to you about the case. And I just would echo what Wendy said. I love talking about this case, and I'd be happy to, talk offline, one-on-one with anyone who has questions that weren't answered today. Feel free to reach out anytime. The war stories that have a happy ending, us criminal lawyers love to talk about. So I'd be happy to return your call. And thank you again for joining.
And Nick, would you like to say any concluding remarks?
Thanks, everybody, and have a great day or a great night.
Thank you all. Bye now.
Bye.